Well, hello, everybody. Good evening. Good to have you with us. My name is Ed O'Malley. I have the privilege of serving as president and CEO of the Kansas Leadership Center. You're at the Kansas Leadership Center tonight. Welcome, especially to those of you who haven't been here before. KLC got started 15 years ago. I had the opportunity to move to Wichita to start KLC 15 years ago. We exist, the reason we exist is to help all sorts of organizations and individuals across Kansas exercise more leadership to solve tough problems. And I could give you a longer version of what KLC is if you're interested. But I want to just talk for a minute about why KLC is doing this tonight. Why did the city ask the Kansas Leadership Center to help with an event like this? I just want to mention a few things. From the beginning of our time as the Kansas Leadership Center 15 years ago, we've worked incredibly hard to have all sorts of partners from all sorts of parts of the state, all sorts of sectors, and frankly, all sorts of perspectives on tough issues. And that's been very important to us over the years. We also, over the years, we publish a magazine. Some of you may have seen it. It's called The Journal. And that magazine over the years has done a great job helping dissect really tough issues, but do it in a way where people on all sides of those issues can see their views reflected, right? And create a space where we can learn together and understand one another better. But also, KLC over the years has worked incredibly hard to have formal partnerships with organizations from all different perspectives. So even like tonight, Kendall is from GLSEN. That's one of our longtime partners at the Kansas Leadership Center. And Chuck from the Catholic Diocese is here as well. And that's another longtime partner from the Kansas Leadership Center. So we work really hard to have lots of different partners from the education sector to the social service sector to the faith community sector to the business sector. So my sense is it made sense for KLC to be an entity to host a conversation like this tonight. You'll hear more about this, but this conversation is just one out of a handful of different opportunities that exist in our community to talk about the Non-Discrimination Ordinance. You'll hear more about those opportunities. Tonight, the whole idea of tonight really revolves around what we call the collaborative premise. The collaborative premise is something we believe deeply, and what it in essence says is if you got a tough issue, the best thing you can do is bring the right people together, which, by the way, aren't always the usual people. Okay? Bring the right people together with good information in a healthy process, and you're going to get somewhere. You're going to get some results. We might not all agree. That's not necessarily the goal, is for everybody to walk out of here tomorrow night agreeing. But if we have the right people together in a healthy process, with good information, you'll get results. You'll get good results. We found that to be true over and over and over again in community and civic life. That's what tonight and tomorrow kind of represents. Of course, the Kansas Leadership Center, we don't have a position on the NDO. We're not here to make a recommendation. Our role is to help facilitate this process, help provide good information and the opportunity for us all to learn together. I wanted to describe what I think success looks like tonight and tomorrow. And then I want to hand it over to Julia Favors-McBride, our Vice President, to take us further tonight. To me, success is we all learn a bit. We are able to step back and learn a bit about what actually is in the law, what's in the ordinance, what questions do we have? Can we all get on the same page with some basic information? That would be one level of success. Maybe another type of success would be that we listen to other perspectives just to better understand where they're coming from, not necessarily to change our mind, but to better understand where are the different perspectives coming from. Maybe we discover where there are points of agreement, and maybe we clarify where there are points of disagreement. We get more clear on what actually is the disagreement. Okay? Nothing wrong with disagreement in this world, right? But if we can get more clear about what is the disagreement, that could be useful. So to me, that's what success looks like tonight. Julia will say a few more things about that. I do want to thank each and every one of you for coming tonight. I know there are other commitments that you could have spent your evening focusing on. So thank you for being here. I want to thank the Diversity and Inclusion and Civil Rights Board for all the work they have been doing. They are a part of tonight as well. Also want to thank the KLC team that has put this together very, very quickly. You'll meet Jonathan and Tina and Julia. I think you've all heard from Dennis Clary. So Dennis, just raise your hand in the back real quick. Dennis is, we might call Dennis the mastermind or the project manager or the project lead. He's been the one working to keep this whole thing together and done a great job of it. So Dennis, thank you for your time and effort, and to the whole KLC team. With that, Julia, I'll hand it to you.
Thank you, Ed. And thank you, everybody, for being here. I am Julia Fabris McBride. This is Tina Kahn and Jonathan McCroy, and you'll hear from them a little bit later. We're your facilitation team this evening and tomorrow evening. And we're working with Julian Montes, who's running technology. So I want to frame up what will, broad strokes, what we'll be doing over the next couple of evenings and what we hope to accomplish and some suggestions for how we work together. So Julian, could you put the dates up? Yeah. So on July 13th, 2021, the Wichita City Council voted to delay a decision on the Non-Discrimination Ordinance, the proposed Non-Discrimination Ordinance, for 90 days. We're in the midst of that 90 days, September 7th and 8th. This is a public meeting of people who were identified and organizations who were identified by the city manager's office in collaboration with the Diversity, Inclusion, Civil Rights Advisory Board in collaboration with KLC. So that's how you all who are in the room got on a list to be invited in this room. This is a public meeting, not a public forum. So we will hear from those in the room, the stakeholders, the advisory board, and not from members of the public this evening. We are live streaming this meeting. The public can observe what's happening. We also have the opportunity for some people to be in the building as much as COVID protocols allow. So that's tonight. On September 21st, there will be a meeting, a formal meeting of the advisory board. I'm sorry, I missed one. On the September 15th, the Diversity, Inclusion, and Civil Rights Advisory Board will have a public forum. On that evening, members of the public can come and speak. September 21st, there's another public meeting where you all are determining your recommendations to the City Council. And if all goes as planned, on October 12th, the City Council will vote. So while this is not a formal meeting of the advisory board, a quorum is here and a couple joining on Zoom. So we are following the Kansas Open Meeting Act. And as I said, this meeting is open to the public via live stream. We are hoping, as Ed talked about, that this can be a different kind of conversation than you usually have about contentious issues. So there's some objectives for these next two evenings that we want to share. So our objectives are that we will all hear the same information, including from two attorneys from Folston, and gain some clarity, have a chance to ask questions and gain some clarity about the contents of the Non-Discrimination Ordinance. People mostly tomorrow, tonight's focused on clarity. There'll be opportunities tomorrow to talk, and at the end of this evening, to talk about perspectives. We want to create space here tonight and tomorrow evening for you to listen to perspectives that may be very different or slightly different from your own. We're not asking you to change your minds. We are asking you to listen. And we are going to work to identify points of consensus and difference. And that will be included in a written report. That Stan Finger is here at the back of the room here, is a journal contributor, the KLC Journal contributor, and Stan will be working on a report that will go to the District Advisory Board that will summarize and contribute to their understanding of stakeholder perspectives on this issue. So let's work together to accomplish those objectives tonight. We know there are differences of opinions in this room, and again, we're not asking you to set aside your opinions about this ordinance or proposed ordinance. We're asking everyone here to do what you can to make sure we hear the information that you're going to hear from Teresa and Emily later on. That each of us has an opportunity to voice some perspectives, and that we have that space to identify points of consensus. So we have some suggestions for how we're going to work together, and then I'm going to hand things off to Tina and Jonathan to facilitate some introductions. So making the most of our time together, these are suggestions for how that might happen based on our experience. So the first one is probably the hardest. It's about holding steady even when it's hard. Doing whatever you need to do, taking deep breaths, staying in the room, taking a break if you need a break, and coming back when you're ready to come back. So hold steady even when it's hard. That's our request of all of us. Help get the range of perspectives in the room. Share your voice and make room for other people who have different perspectives. Listen actively. Do what you need to do to stay present as much as you can. Commit to sharing and learning, not debating. This is not, there are other forums for debate. This one is for sharing, for learning, for getting some information and some clarity about where we agree and where we don't agree. I think it goes without saying, avoid assumptions, blame, speculation, and inflammatory language tonight and tomorrow night. And just in terms of like housekeeping, we're going to be using the microphones. We need those microphones. You'll need to turn on the microphone when you speak. We'll probably have to share the microphone. There's microphones all around the room, but we'll have some KLC staff help if needed, but it keeps things moving faster if we can just pass them around. So get a microphone. Tina, Jonathan, or I will call on you, and we'll make this all work together. And just to allow us to facilitate, sometimes people say the definition of facilitation is interrupting all the time. We may interrupt, and that's just because we are committed to having a process that gets us towards where we want to go and that gets you out the door at 8 o'clock. So broad strokes, the plan for tonight is to set us up for a different kind of conversation about the Non-Discrimination Ordinance by taking some substantial time for introductions. We are going to, again, hear, and I'll introduce them more, hear from Teresa Schulda and Emily Mata from Fulston Attorneys at Law later. And we'll get your questions answered as much as they are able. And we'll start to identify points of consensus and difference in the very last part of this evening. And we'll have much more time for that tomorrow. Now I'll breathe. Tina and Jonathan? Yeah.
All right. Hey, everyone. Thanks for joining us this evening. We greatly appreciate you taking the time. As Ed said, there's a myriad of things you could be doing tonight with your few hours. So thank you for taking time to give back to your community and have a conversation in a different way. I really appreciate that from my heart. Thank you. So we want to, Julian, let's have this slide. We want to know who's in the room with us tonight and who's joining us. So we're going to do a little bit different way of introducing ourselves. So we're going to grab a shoulder partner, but given our social distancing, we might have to move to find a partner if we've got some space. Okay, so we're going to need you to introduce yourself to your partner, your name, your affiliation and organization, and what you would be doing at 6 o'clock on another Tuesday night if you weren't at the Kansas Leadership Center. So with that, I would say, hey, I'm Tina Kahn. I am with the Kansas Leadership Center field team, and I work in rural community food systems. And on a Tuesday night, if I weren't here, you would find me out in the Flint Hills on my bike. I'd like to pedal my bike.
Wow. Well, nice to meet you, Tina. I'm Jonathan McRoy, a member of the KLC field team. And on a typical Tuesday night, I'd probably be at home making dinner, probably some chicken and some rice, something like that.
Now here's the interesting twist. We're going to put about 3 or 4 minutes up on the clock. You're going to do your introductions, but you need to be prepared to share out to the group by introducing your counterpart. So I would let you all know that my colleague that I've just met this evening is Jonathan McRoy. You'd find him making chicken and rice on Tuesday night at 6 o'clock. Okay? We understand? Thumbs up if we're all clear. Excellent. So 3 to 4 minutes for that quick intro, and then we're just going to start letting you take a mic and introduce your co-partners. Okay? Thanks.
Our friends on Zoom here, I will be moving you into a breakout room shortly to do this activity.
Okay, they're off and running.
Yeah, hey.
Yeah, like, you don't need
I was ready to go with the script or without it, whatever you wanted to do.
Just about 2 more minutes with your intros, and we're going to have you introduce your partners. Just a couple more minutes. celebrations of new partnerships. So thank you for that. We're going to try to get through this in about 15 minutes. We've got a lot ahead of us this evening and certainly tomorrow night. So grab a mic, and we're just going to popcorn style this, make sure no one's left out, and feel free to introduce your counterparts.
Do you want me to go first?
Online, we're going to leave you just to the end.
Okay.
Was that an online? Thanks. Thanks, Jen.
Yeah, I'll go first. I'm going to introduce Gentry. Gentry, everyone. Gentry is currently working with the Realtors of South Central Kansas, and she is the Government Affairs Director there, as she used to work for the City of Wichita. And if she was to be doing something else on Tuesday night, she would be picking vegetables in her garden.
Hi, everybody. Is this on? Yes. Great. So this is Dion Gates. He is on the Diversity and Inclusion Civil Rights Advisory Board. And if he were home right now, he would be catching up on the daily news.
This is Charlie Wilkes. Charlie works at Envision, and on a typical Tuesday night, he'd be at home playing his guitar. And I would encourage you to check out Charlie Wilkes on Spotify. He's got an album there called Golden Hills.
Good evening. This is Con Harton. He's a pastor for the past 20 years, and he's a family man. Usually on a Tuesday night, he's at home with his daughter, having dinner and watching some Hulu. I think he said it was.
We'll go next. This is Kendall Hawkins. She is a special ed teacher. She's also an advocate for GLSEN, which stands for Gay, Lesbian, Straight Education Network. She served in the Kansas National Guard from 10 to 15 and with the 35th Infantry Division. And on a typical Tuesday night, she would be at home doing lesson plans for the following day.
Hi, and this is Julie Sanders. She is a former U.S. Army soldier as well on active duty. She is the co-chair for Greater Wichita Area Veterans Advocacy Board and works at the WSU Veterans Upward Bound program. And on a typical Tuesday, she'd be playing pool with her husband, son, and daughter, having a good time.
Hi, everybody. This is Beth Carlson. Beth is works for Cargill Protein North America. And on a typical Tuesday, she'll probably be walking her English Bulldog, Stewie.
Hi, everyone. Now it's on. Okay. This is Alejo Cabral, and he works for the Wichita Chamber of Commerce, specifically in the talent space. And on a typical Tuesday night, he'd either be just arriving home, cooking dinner, playing with his dog Stella, or heading to the gym because he's working on being healthier. So happy to introduce you to Alejo.
Good evening, everyone. This is my good friend, Mackenzie Borland. She's in her last semester at Wichita State University, where she is studying strategic communications. She'll graduate in December, and typically she'd be doing homework on a night like tonight.
Is this on? Okay. This is Mark McCormick. He works for the ACLU, and he's actually the director of strategic communications, which is my major. So we have that in common. On a Tuesday night, he would be working on a press release or lining up interviews for a legal team. So it sounds like we both kind of have boring Tuesday nights. So
good evening. This is over here. This is T. Fan. She is a engineering student, and on a typical Tuesday night, she would be studying as well.
This is Jackie Carter. On a typical Tuesday night, she would be helping the food pantry at her church. She has been a pastor for Table of Rocks for 14 years now. Table of Hopes.
Is this on? Yes. This is the most incredible man. This is Ed O'Malley, the president and CEO of KLC. And on a typical Tuesday, he'll be using both hands, two different grills, and making it happen. He's a grill man.
Thank you, Renee. I'm not ready to top that. That was amazing. This is Renee Carrion, and she is on the Diversity and Inclusion and Civil Rights Advisory Board. She represents District 6, one of the District 6 appointees on that board. On a typical Tuesday night, she would be doing something related to community engagement and 2 Men and a Truck. She's the Director of Community Engagement for 2 Men and a Truck. So we got you out of one type of community engagement, but you're in another type of community engagement.
I want to introduce my friend, my new friend, Representative Stephanie Byers. She's a state representative here. On a typical Tuesday night, she would be fixing dinner for her wife as she is finishing up meeting with a client. She is an American family therapist, and Stephanie actually gets her grandkids on most weekends, and I know that that's always a joy and fun.
This is Nancy Tanton, and Nancy is with the Cultural Awareness Group. She is normally on a Tuesday night would be spending it with her adult daughters as they kind of have a family dinner night and watch movies together.
I would like to introduce you to Bev Baumgardner. Did I say that right? Awesome. Bev's pronouns are she and her, and she is the associate pastor of West Heights United Methodist Church. On a typical Tuesday night, she would be having dinner with her family. I checked, and I made sure that she wasn't always the one that had to cook. And she says, many hands, I'm paraphrasing, make the work light. But then the best part of Tuesday night is the sunset walk, which is occurring earlier and earlier these days.
And this is my friend Carrie Wilkes, pronouns she, her. Carrie is the chair of Equality Kansas, and she also spends time in her position at WSU. And Tuesday evening is a sacred time for Carrie because she would normally be at her 6 p.m. Pilates class right now. So thank you.
This is Shala Perez, and she's also on the Diversity and Inclusion and Civil Rights Board. And on a typical Tuesday evening, she'd be grading her college students' papers and hopefully giving them all an A+.
And this is Rob Rotola. He is with the Family Research Council, and on a typical Tuesday, he would be watching 24.
One, two. Good evening. It's my pleasure to introduce Tabitha Lehman, and you might recognize that name because she was a former Sedgwick County election commissioner. Currently, Tabitha is serving on the Diversity, Inclusion, and Civil Rights Board. And on a typical Tuesday night at 6 o'clock, she would be spending time with her family. She's got 2 married children, a son and a daughter, and we found we have a lot in common with that.
And this is Steve Decker. He is with Southeast Wichita Community Impact Leadership Team. He said on a typical Tuesday night, he would be relieving his wife of grandson duties until his daughter picks up their 5-year-old grandson. They also have 3 girls, and he also works for the Koch Foundation Stand Together.
Good evening. I'd like to introduce my pew partner, Walter Berry of Berry Companies. And Walter is here representing his company, Berry Companies, which is a construction and materials handling company. I hope I had that right. And today, if he was home, he would be coordinating with his wife as they begin to plan out their logistics for their long-term road trip coming up this weekend.
Thank you, Tracy. It's Tracy Adams. Today she's here representing the AARP, and if she weren't here tonight, she would be at a junior league meeting.
This is Jeff Bennett, as Executive Director of Kansas Family Voice, and typically Jeff would be home nodding actively to the day's events from his daughters.
18-year-old daughter. This is Chuck Weber, the Executive Director for Kansas Catholic Conference. And this is exactly what Chuck does on Tuesday nights, pretty much. No, he'd be home cooking with his family. So.
Thank you to everyone in the room, and we want to be really respectful. We have some joining us online, so Jen or Pastor Pam, if you'd like to hop in and let us know where you're coming in from.
Where I'm coming in from Wichita, Kansas, St. Paul AME Church. I'm a member. Today, I'm pleased to introduce Kelly Grant, who is a business owner, but she is also a part of the Diversity, Inclusion, and Civil Rights Board. On today at 6 p.m., she'd be preparing and sitting down and having dinner with her family.
Thanks, Pastor Pam. I'm actually introducing Jen Brehan. She works for Du Bois Consultants. And on Tuesday evenings, she would be sewing masks because she sends masks to her grandkids in Texas. So that's her typical Tuesday night.
Hi, today I'm introducing Pastor Hughes, who is a local pastor in Wichita, and she is a member of the Diversity, Inclusion, Civil Rights Board. On a typical Tuesday night, she would be relaxing.
All right, thank you so much. And the great thing about having conversations like we're going to have tonight and tomorrow is the ability to connect with one another and continue the similarities and the commonalities and the interests that we all share as community members in this wonderful city. So with that, I'll turn it over to Julia to keep us going.
Thank you, Tina. Thanks, Jonathan. So now we're going to introduce Teresa Schulda and Emily Mata from Folston Law Firm. They will outline with some slides, and I think you have some handouts of those slides, the current state of anti-discrimination laws at the federal and state level, and how the proposed non-discrimination ordinance would overlap or add to existing anti-discrimination law. They'll cover which entities are covered by the various anti-discrimination laws, which categories or characteristics are protected, and how these laws are enforced by federal, state, and local agencies. We have about 15 to 20 minutes of their presentation. Then you'll have time to do a little bit of reflection and identify the most pressing questions you have. We'll take a break and come back and get those questions answered to the best of their ability.
Am I on? All right, good evening. Thank you for having us here, and thank you to KLC for giving us this opportunity. I am Teresa Schulda, and my colleague Emily Mata is here with me tonight. And much like the KLC, we don't have, our firm does not have a position on the non-discrimination ordinance. Our goal tonight is to sort of level set what the law is at the federal, state, and in the proposed NDO with regard to anti-discrimination in three primary areas: employment, housing, and public accommodation. All right, I'm going to cover the employment part if I can figure out. There we go. So the first slide is just kind of a flavor for how complex this area is. We call this the alphabet soup of employment laws. You can see in the federal arena, it takes, upwards of 8 laws to cover this area. So we'll kind of talk about what protected categories these laws cover, but in the federal arena, we have Title VII of the Civil Rights Act of 1964. That is the law that prohibits discrimination on the basis of race, color, national origin, sex, and religion. Did I get those right, Emily? And then we have a law that is called Section 1981 in my vernacular. It's a statute that's 42 United States Code, Section 1981. That is a law that covers race, ethnicity, and color discrimination. Then we have the Americans Disabilities Act which was passed in 1991, I believe. And that, of course, protects against discrimination on the basis of disability. I do want to point out in the arena of disability discrimination, it's not just a current disability, but the protection extends to a record of having a disability. So for example, if an employee had cancer in the past but is in remission, that record of having cancer would be considered a record of a disability. And then it also covers a claim called being regarded as disabled. So if the employee does not actually have a mental or physical disability, but the employer regards the employee as disabled, then that is a protected category under the Americans with Disabilities Act. And then we have the Age Discrimination in Employment Act. This law was passed in 1967, and it prohibits discrimination on the basis of age. And one thing when I started practicing in this area that I was surprised to find is that 40 is the threshold for being an older worker, which nowadays with folks working well into their 70s, 40 might sound young, but 40 is the threshold for protected age discrimination. Then we have USERRA, which is the Uniformed Services Employment and Re-Employment Restoration Act. This is the law that prevents discrimination against employees who are military members and veterans, and requires employers to reinstate military members after they need to go on active duty for a period of time, or they need time off from work to serve in the National Guard, things like that. And then we have the Genetic Information Non-Discrimination Act. That law prohibits discrimination on the basis of genetic information. That has a lot of application in the area of employer health care plans, and it also has some application in other areas as well. The Equal Pay Act prohibits discrimination on the basis of sex with regard to pay disparity. And then we have the Immigration Reform and Control Act, which prohibits discrimination on the basis of citizenship in certain respects. So you can see at the federal level, the covered, it's not every employer, it's employers with certain numbers of employees depending on the kind of law at issue. Still pretty small employees or employers with not that many employees, but it doesn't get down to the very smallest employers. And that's where the state law comes in. So the Kansas Act Against Discrimination, it prohibits basically the same as all those other categories above, race, religion, color, ancestry, sex, disability, military status. But it covers employers with 4 or more employees. So it reaches those smaller employers in the state. And then we have the Kansas Age Discrimination and Employment Act, and again, that's basically the same as the federal law in terms of anti-discrimination provisions, and it does have 40 as the cutoff. Until fairly recently, and by fairly recently I mean in the last decade, it actually had 18 as the cutoff, but that law was amended in the last decade, and they moved that age category up to 40. And then we have the Kansas Discrimination Against Military Personnel Act. That's sort of the state counterpart to the federal USERRA law, prohibiting discrimination against our employees in the military. And now we have the Wichita Proposed Non-Discrimination Ordinance. And we'll talk about what protected categories are covered in the Wichita NDO on the next slide. It adopted the same definition of covered employers in terms of size as the Kansas Act Against Discrimination. And so right now, it would apply to employers with 4 or more employees. Okay, so here's our covered protected categories under these laws. And you see there's a lot of overlap here. All the federal, the state, and the Wichita Proposed NDO, they cover race, color, national origin. The state and the NDO covers ancestry, and then only the NDO has familial status as a protected category in the area of employment. Now, some of the other federal laws, such as the federal housing laws, they have familial status within the housing laws. But here in the Wichita NDO, it does have familial status as a protected category in the context of employment. Now we get to sex. All of them cover sex, right? And then we get to sexual orientation. The Wichita NDO specifically calls out sexual orientation and gender identity as protected categories in the proposed language of the law. Now, under the federal law, that would be Title VII of the Civil Rights Act of 1964. It prohibits discrimination on the basis of sex. But in June of 2020, so just last summer, the United States Supreme Court decided a decision called Bostock. And there they considered whether or not discrimination on the basis of sex under Title VII extended to discrimination on the basis of an employee's sexual orientation or transgender status. And the court ruled that it did. So Title VII did not have to incorporate those specific categories and name them in the law, because the Supreme Court has determined as a matter of law that the term sex covers those categories. So then we move to the state law. The state law, like the federal law, it says no discrimination on the basis of sex, and it does not specifically call out sexual orientation or gender identity. After the Bostock decision from the Supreme Court in 2020, the Kansas Human Rights Commission, which is the state agency that administers the Kansas Act Against Discrimination, the Kansas Human Rights Commission, they interpreted the state law consistent with the Bostock decision. And the state law is very often interpreted by the courts and by the state agency as consistent with the federal law. So when I'm litigating a case and the state law is at issue, the courts and all the parties very, very typically rely on the federal case law because there's just more litigation in the federal arena. So it's not uncommon for the state to rely on the federal law for the interpretation of the Kansas Act Against Discrimination, and that's what the Kansas Human Rights Commission did. So by extension of Bostock, the law in the federal and state arena does prohibit discrimination on the basis of sexual orientation and gender identity. Now, the Wichita NDO, it also specifically says we prohibit discrimination on the basis of actual sexual orientation or gender identity or perceived sexual orientation or gender identity. Now again, that was not addressed by Bostock specifically. However, there has been a long-standing body of law in the Title VII arena that deals with sex stereotyping. So since the 90s, decades now, the courts have said a form of sex discrimination is imposing sex stereotypes on employees. So the famous case is called Hopkins versus Price Waterhouse, where it was a woman who was trying to be a partner at Price Waterhouse. She was up for partnership, and she was denied partnership, and her evidence of sex discrimination was that she was repeatedly told by her male partners, you should dress more femininely, you should act more feminine, you should wear jewelry, makeup, etc. And the Supreme Court said, hey, imposing sex-based stereotypes on employees, a woman is not as feminine as you want her to be, a man is not as masculine as you want him or expect him to be, that is a form of sex discrimination. So even though it's not called out, the perceived isn't called out, there is a body of law in the federal and the state arena that deals with sex stereotyping. And I will say that gay and transgender employees have successfully pursued litigation in the Title VII arena under that theory. Then we have disability discrimination. It's covered by all the laws. Age, genetic information is covered by the federal and the proposed NDO. Citizenship we've got covered by the federal law. And then veteran and military members has got some overlap there as well. There are some exceptions to the law, and some of these are going to get a little repetitive as we talk through. I'm going to use up all of our time, Emily. So one of the exceptions is something called a bona fide occupational qualification. And this is where I'll give you the example of the requirements for a person who works as a fireman or a firewoman. And if the requirement is you have to be able to pull a 150-pound human body out of a burning building, and let's say that has a disparate impact on the hiring of female candidates. So we don't hire as many female candidates because fewer female candidates are able to pull that 150-pound body out of a burning building. The law has said, well, it's pretty important to be able to pull a 150-pound body out of a burning building. So we're going to allow that disparate impact to occur because it's a bona fide occupational qualification. The law also recognizes reasonable dress and grooming standards, especially when there's safety involved. There's also a ministerial exception in the federal law. That is where a religious-based organization is hiring ministers. And ministers has a very broad definition. It extends, for example, in the context of religious schools to teachers who have some function of teaching the underlying faith of the organization to the students. So when religious affiliated organizations are hiring and employing ministers, they really are exempt from the civil discrimination laws because of the religious freedoms under the First Amendment. And the courts have recognized the ministerial exception in that context. Undue hardship, that happens in the accommodation context. So if I have a disability and I ask for an accommodation that would cause an undue hardship on the employer can say, well, we can't make that particular accommodation because of the hardship it would impose. I will tell you that's a very, very hard burden to prove as an employer. Direct threat, that's another area where it's an exception. So if you have an employee who has a disability, but their disability causes a threat in the workplace, there's a famous case of a person who had post-traumatic stress disorder, and he said, at any moment, I'm gonna lash out and punch my coworkers. There's no accommodation that will prevent it from happening. It's definitely going to happen. And he was fired, and the court said, well, he poses a direct threat. His disability poses a direct threat. And then bona fide seniority systems based on age, and those you can get away with bona fide seniority systems, and even if it has an impact on age and pay issues, that's an exception. The state law follows the federal law. The NDO proposed, it follows the NDO. NDO follows the federal law. And then the NDO in Wichita, it specifically calls out some exceptions. And it says, this law will not be construed or apply in any manner that violates the First Amendment of the US Constitution. And you all know the First Amendment. It covers free speech, the exercise of religious freedom, and the Establishment Clause that says government will not establish religion. And then Section 7 of the Kansas Constitution, that's basically the state counterpart to the First Amendment of the US Constitution. The Kansas Adoption Protection Act, that law says that if a religious-based agency is performing adoptions in the state, that it is not required to provide services that would conflict with that religious entity's faith-based beliefs. And then the Kansas Preservation of Religious Freedom Act. That law in Kansas, it says that the state won't pass any laws that would be an undue burden on a person's exercise of religion unless there's no less restrictive way of accomplishing a compelling government interest. This is all Constitutional Law 101. It takes me back, this language. Basically, the law has to promote a compelling government interest and be the least restrictive way of doing it if it's going to infringe on a person's religious freedoms. The enforcement in the federal arena, this page is basically kind of how a complaint gets to where it needs to go. At the federal level, it's largely through the Equal Employment Opportunity Commission, and complaints typically have to be filed within 300 days or else they are barred under the statute of limitations. In Kansas, it gets filed with the Kansas Human Rights Commission, and it has to be filed within 6 months. And in Wichita, it would be filed with the city clerk, and it has to be within 60 days. So that's a difference. It's a much shorter statute of limitations to file a complaint in the city. And then the damages that you can get if you're successful in pursuing a complaint are very different between the federal, the state, and the city. The federal law, I'll tell you from my experience, that's from an employee's perspective, it's the most lucrative law in terms of the types of damages you can get, and that's where I see the litigation is in the federal arena, because the damages that are available are much broader than what are available at the state level and at the Wichita NDO level. So at the Wichita NDO level, the damages are $2,000 per violation. Okay, housing, a lot of this is a repeat. I want to get to public accommodation because it's important. So the federal is the Fair Housing Act and the Equal Credit Opportunity Act. That second one really covers mortgages and being able to get a loan. And the Fair Housing Act covers exactly what you think it does. It's you can't discriminate in renting houses, terms and conditions of leases, etc. And then the Kansas Act Against Discrimination, it's the state counterpart. And then the Wichita NDO applies in the City of Wichita. And frankly, they really cover kind of the same covered housing. There's not a lot of differences. There is quite a bit of a difference in the protected categories. So in the federal arena, again, the kind of areas where there's been a lot of discussion with the NDO are sexual orientation and gender identity. So the federal and the state laws do not specifically call out those categories, whereas the Wichita NDO does. However, President Biden, in January of 2021, he passed an executive order where he basically said the federal laws will be construed to prohibit discrimination on the basis of sexual orientation and gender identity. So via that executive order, the federal laws do currently cover those categories. You know as well as I know that an executive order is only as good as the administration in place, and so with switching administrations, that executive order could change. The Kansas Human Rights Commission, they adopted the Bostock decision that said sex discrimination on the basis of sex extends to sexual orientation and gender identity, and they applied it to all, so not only employment, but to housing and to the public accommodation arena. So those areas are covered by the in the state law because of the Kansas Human Rights Commission interpretation of Bostock. And then again, we kind of go, and the federal law doesn't cover age, genetic information, veteran or military members, and those get covered under the Wichita NDO. So in Wichita, you wouldn't be able to discriminate on those categories either. There are some exceptions, basically, you know, people who are small real estate investors and only own 3 or fewer rental properties. They're not covered by any of the laws, federal, state, or Wichita NDO. Owner-occupied residents. So if I own a house and I live in that house and I rent it out to fewer than 4 families, but I live there, I would be excluded from these laws. Religious organizations, if they are renting out establishments for non-commercial purposes, they can prefer their own religious affiliation in the context of renting, etc. And those kind of apply all the way down. And again, the Wichita proposed NDO specifically calls out the federal constitution, the state constitution, and those laws in Kansas is saying this law will not be interpreted to conflict with those other existing laws. Okay, I used up almost all the time. And now I'm going to give it to Emily to cover public accommodation.
Right. Is this thing on? All right. Great. On to public accommodations, I'll try not to sound like an auctioneer going through this. We can always ask questions, follow-up questions as we go. But basically, what does it mean to discriminate in public accommodations? the basic principle is that there's an entity or an organization that provides goods or services or facilities to the public, and they are limiting those services or goods, they're withholding services or goods, or denying services or goods because of a person's membership in a protected category. And so what we hear in the news are these cases in like Masterpiece Cake Shop involving businesses in the wedding industry and whether they have an obligation to provide services to LGBT individuals. And so I'm going to go through briefly what are public accommodations and the definition. Huh? Oh, am I ready? Oh, sorry about that. There we go, that helps. Okay. So Title II of the Civil Rights Act is the first primary federal law covering public accommodations. It covers race and color and national origin and ancestry. And so it sets forth 4 categories of public accommodations. And some courts have said that if you don't fall within one of these categories, you are not a public accommodation. So like retail establishments, a clothing store, or a bank might not be covered by this federal law. So here we have lodging, a hotel or a motel, a restaurant or a cafe, any kind of eating establishment, as well as entertainment establishments, so like a movie theater or a stadium or a concert venue. And then any kind of entities that share a space and hold themselves out to be available to offer goods or services to the public. So they share a building, and there's some confusion about whether they are a public accommodation. The law just says, yeah, you both are public accommodations. We're just gonna give people credit for that. The other primary federal law is the Americans with Disabilities Act. This is a separate wing from the employment context, of course. So the public accommodations definition is gonna be the same as Title II. It's gonna cover lodging and eating establishments, but it's gonna be much more broad and encompassing. It covers retail establishments and public transportation, grocery stores, and of course that only covers disability. Under Kansas law, you have a broad definition basically of a public accommodation is an individual or a business or entity that offers goods or services and facilities to the public, and then it provides a list of examples. And so that's a non-exhaustive list. There's more to it. And the Wichita NDO is essentially the same as CAD, the Kansas Act Against Discrimination, but it is limited to establishments in Wichita, and it includes exceptions. For example, establishments that are operated by a nonprofit, fraternal, or social association group aren't going to be public accommodations, as well as bona fide civic, political, or religious organizations that restrict who they provide products or facilities to only members of their organization or group, or individuals who promote their principles. So here's the protected categories, and as you can see, federal law is pretty limited in what's going to be covered. For example, one of the big ones that always catches me by surprise is that sex is not covered. Sex discrimination in federal public accommodations law is not prohibited. So by extension, sexual orientation and gender identity are also not prohibited. Age is also one that I would probably note. Veteran status and military status as well. So I won't go through all those, but as Teresa said, Kansas state law includes sex discrimination prohibitions, and the Kansas Human Rights Commission has extended that to sexual orientation and gender identity.
And the Supreme Court has very unhelpfully declined to clarify the federal law that has been presented to them in the Masterpiece Cake case, and they issued a ruling that was very narrow and did not answer the question that I'm sure all of us have in the federal arena, which is does the law cover sex discrimination, including sexual orientation and transgender status?
Right, and so the NDO has a lot more coverage. Genetic information, familial status is covered, as well as veteran and military status as well. And so here's the exceptions to public accommodations laws. There's several of them listed here. Under Title II for federal law, private clubs or any kind of establishment that is not open to the public. Under the ADA, it has that same exception, but it also includes religious organizations, And then Teresa mentioned direct threat and undue burden in the context of whether you have to provide a reasonable accommodation. So I won't go over that one again. Under Kansas law, there are two explicit exceptions. Religious or nonprofit fraternal or social associations or corporations are not covered by state public accommodations laws. And in some situations, you can discriminate on the basis of sex where it is necessary because of the nature of the accommodation. Under the proposed NDO, there's several explicit exceptions. Religious organizations that perform religious functions, and the term religious functions is included in the NDO, and there's a couple examples that it provides. So the first one is any kind of service or facility or anything related to like a marriage ceremony. Or the other example is anything related to like a religious organization's ministry or teachings or advancement of its religion. And then, of course, we have the same exceptions, as Teresa mentioned, relating to free speech and, yes, free speech and freedom of religion. Okay. So the enforcement at the federal level, Title II is kind of interesting. There's not really an enforcement agency. There's a weird wrinkle where if there is a state or local law governing prohibiting discrimination in public accommodations, and it has similar remedies. So I would say probably CAD qualifies for this, and the NDO probably would as well. You have to first file a complaint with that state or local agency, and then you have to wait 30 days to give them an opportunity to intervene, I guess, and then you can go ahead and file your lawsuit. You have 2 years to do that. The Americans with Disabilities Act doesn't require you to file any kind of complaint, although you can file a complaint with the Department of Justice, their disability rights section. There are several other agencies that enforce the Americans with Disabilities Act, for like Department of Transportation is one of them, and so where you file your complaint might depend on where that accommodation falls. You have 2 years to file that lawsuit, and then the remedies. One notable thing is that monetary damages are not available unless the Attorney General were to intervene in your case, which they may do if they see that there's a pattern or practice of discrimination or a good reason to do so. With ADA claims, there is a pretty steep civil penalty, a max civil penalty of $150,000, depending on how many prior violations. Under Kansas law, it's going to be very similar to the employment context. And one thing I'll note is that equitable relief, what does that mean? It might be basically requiring this business. The court would say, hey, you have to go ahead and provide this service or good to this individual because they've shown that you have wrongfully discriminated against them. And of course, the Wichita proposed NDO has the same enforcement scheme that Teresa already went through. So I won't bore you with the details on that. And I think that's it.
I want to point out one thing on the enforcement provision in the NDO, and I know we went past our time.
Yeah.
So under the enforcement provision in the NDO, it very specifically, it kind of has this process where you file a complaint and then it goes through an investigation. Actually, first it goes to a mediation and you see if you can mediate the dispute. And if that doesn't work, it goes to an investigation, and then it goes to the city's law department. And the law department has to make a determination of two things. One, whether or not there's probable cause that the ordinance was violated. And two, the law department has to determine whether the penalty would cause an undue burden on the person's religious beliefs, and if so, does the penalty further a compelling government interest, and is it the least restrictive way to further that compelling government interest? So there's, again, kind of they're bringing back into the enforcement provision concepts of considering issues related to religious freedom. And we took up more than 5 minutes of our time.
Thank you, Teresa and Emily, for unpacking the federal, state, and proposed ordinance for us. We're going to go to break, but before we do that, I have some instructions for you. If we can get to the next slide. So now that we've heard all of that, I'm going to have you generate some questions for understanding and clarity. Okay? So while you're on your break, you're going to utilize the sticky pads in front of you, and you're going to consider, what about the existing federal and state law is still unclear to you? What about the proposed municipal ordinance is still unclear to you? And what is the most pressing question you have for Teresa? So you're going to take those, take the yellow sticky cards. We're going to go on break for 15 minutes. There will be a chime prior to at a 5-minute mark, and we'll return. Thank you. Have the opportunity to phone a friend while you're on break to get some feedback and bring that back with you. Also, please take the time to utilize the restroom and other things you have to get done before we return. Okay, thank you.
Thanks, everyone.
Okay, we're back. And we have more time with Teresa and Emily. Thank you so much for all the work you've done to prepare. So please take out your Post-it note that has the most pressing questions for our attorneys. And by our attorneys, I mean the attorneys.
We are also KLC's.
Yeah.
And we'll do our best to answer your questions, and even where we don't have the answers, we'll try to look it up and catch you during a break.
And my thought is, let's save your Post-it, and we'll collect those at the end so that we have a record of what those questions were. And I'll do my best to call on you as we go. So raise your hand and get to a mic. Yeah, so we'll start with Robert. And if somebody can get the man a mic.
Give me a softball, Robert.
Yep.
You're up first. I need an easy one.
Okay, I get to ask one of these, right? Not
One. Start with one. Yes.
only one.
One.
Okay, only one. So we employ well over 100 and whatever, 30 people. And it has been ruled that teachers in a faith school are not considered ministers for tax purposes, for sure, even up to the principal, even if they teach a little Bible and this and that. But you stated in this that they are definitely considered ministers in this ordinance, which is in direct conflict with what we've gotten from our lawyers for 32 straight years.
So the ordinance, it doesn't specifically call out the ministerial exception. So I was talking about the ministerial exception in the context of federal law and Title VII. And the ministerial exception doesn't necessarily apply to every single teacher. So if you had a teacher who had no responsibility for teaching any kind of faith-based curriculum at all, no responsibility, then it wouldn't necessarily apply to that teacher. But in the federal context, the way the case law, and let me tell you, law in the employment arena versus the tax arena versus ERISA benefits arena versus something else, it can change, it can vary. It's not necessarily all the same, and it's not necessarily all consistent. But in the federal arena under Title VII, there have been a series of cases, and one was this Hosanna Tabor case where they did apply it to a teacher, and it was a teacher who sued for disability discrimination. And they said, we're not even going to listen to your case because the job that you had was in part imparting the tenets of the faith to the students. You took them to mass every day, you did all that stuff. So
if a religious organization like ours, to make sure I understand it, if we designate that every one of our employees, which is the current expectation, demonstrate the faith, teach the faith, even if they're a baseball coach, they huddle up with the team and they teach them Christian principles. If every one of our 100 and something staff members all are required to teach the Christian faith, will they all be covered by this NDO?
Meaning, what you're saying is, would the entity be exempt from the application and enforcement of the NDO because it employs ministers? I can't answer that question.
Right.
It's too far out into the future. Right now it's a proposed law, and so it's too far out. I couldn't even answer that question in the federal arena because it would be kind of this case-by-case analysis. But what I can talk to is how the ministerial exception has been applied in the context of the federal law. And the NDO doesn't specifically call out ministerial exception. Neither does Title VII, I don't think. I'd have to look that up. But it's this concept of an exception to the law.
Yes, ma'am, it's not covered is what we have been advised by our lawyers. It is not covered, firmly not covered. So it ends up discriminating against our Christian faith for sure. I just want you to know that.
Under the tax law?
Under the tax law, for there to be a ruling in the NDO to go against what's been on the books and the tax law, where they are definitely proven to be not ministers, and there is in writing they are not considered ministers, that would be used against us in any case-by-case basis.
I think you have your question answered. Yeah, thanks. Thanks. Nancy, and then we'll go over here. Yeah, thanks.
Who am I looking at? Am I
We're
looking at Kendall?
At Nancy.
I'm looking at Nancy. Okay.
Looking at me. I have a comment and a question that would go along with
Let's
that.
stick with the questions.
Okay. Would it be possible on this NDO to simply put a period after religious organization, because the statement after that is what is confusing and restrictive?
And Nancy, we'll get to those kinds of ideas tomorrow.
Okay.
And it's starting at the evening, starting at the end of this evening and
Okay.
tomorrow.
Okay.
For now.
But the question is out there.
And just to clarify, neither Emily nor me or our firm had any role in the drafting of this ordinance whatsoever.
Right.
So we took the ordinance as written and we took the sections out of it and put it in the slides. But I can't answer any questions related to drafting.
Okay.
Yeah, so for now we want to talk about
All right.
questions related to the non-discrimination ordinance that's proposed and the federal law. So Kendall, and then Con, and then Carrie.
Okay, my question is, can a new administration change the Kansas Act Against Discrimination interpretation applying Bostock to state law? And who seats those KHRC members?
So the simple answer would be yes. So you're talking about the state administration, the state executive branch. And so the Kansas Human Rights Commission is part of the executive branch. And so the executive branch does control those decisions. And so yes, you could have in theory, you could have a Kansas Human Rights Commission that reverses its interpretation. It can't reverse the interpretation of Bostock. That would be, they just can't do that. Bostock is Bostock, it's the Supreme Court. So, but they could reverse the interpretation of Kansas law.
Get the application of Bostock to the Kansas law, correct?
In theory, yes.
Thank you. Con, and then over to Carrie.
I'm right here.
Yeah.
Con?
Sorry. So, in the absence of a definition for the word discrimination, does that filter its way down to the legal department of the city, or how is that settled since there's no definition?
There is a provision that describes what falls within the rubric of discrimination. There is a section of the NDO that does say, here's what types of conduct are prohibited, and it falls into general categories. And so there is a section in the NDO that does talk about the types of prohibited conduct in all of the three areas. So employment, public housing.
Right, but there's no definition of the word discrimination. So that's where I see some problem issues there.
Thank you. Carrie? And then we're going to go to Julian, who has a question from Zoom.
Okay, I had just kind of, this isn't my main question, but I did notice that you said there was a $2,000 penalty. And unless it's changed, I believe it's up to $2,000. So that might just be one.
Yeah, no, you're absolutely correct.
Okay.
Up to is the correct. You're absolutely correct.
Okay.
Good catch, Carrie. We should update our slides.
No, that's
Up
okay.
to is absolutely correct.
But I considered that more of a technical thing. My real concern is similar to kind of what we just heard about the Kansas Human Rights Council, with their following the Bostock interpretation. Because this, in theory, they could change, to me is actually fact, because my organization has watched them rescind an interpretation and change it as it's related. So I'm very concerned about what seems to be a presentation as if that was like etched in law. And to me, it seems like this is an interpretation. Interpretations can change.
So the buck always stops at the courts. And so the administrative agency can say, so for years, the EEOC at the federal level, for years, they said we interpret sex discrimination to be discrimination on the basis of sexual orientation and gender identity. For years, the EEOC said that. That didn't mean all the courts followed. And there were courts, that's why it went to the Supreme Court, because there was a patchwork of interpretation. And the courts who didn't follow the EEOC, they said, we're gonna follow the precedent in our jurisdiction. So at the end of the day, you know, if the KHRC reverses course, the courts in Kansas would really be where the buck stops in terms of the interpretation of the Kansas law. But let me tell you the practical reality. The Kansas law doesn't get litigated very much because if you have at least 15 employees, every litigant will go under the federal law because the damages under the federal law are more lucrative than the state law. And so the Kansas law just doesn't get litigated as much. So yes, there could be a switching of administration and interpretation. The courts still are where the buck stops in terms of the interpretation of the law. And then if the legislature in our state doesn't like the way the courts interpret it, then they change the law.
Thank you. We're going to a question from, I believe, Jen, yes? That Julian's going to read?
Yes. So Jen writes here in the chat, I'm unclear on if a case is filed for discrimination of any kind, race, age, disability, sexual orientation at the federal and state level, and the administration changes hands. How are those cases then evaluated or handled, or are they just dismissed, or do they just sit there unresolved?
No, they go forward. They go forward. So if you have, let's say that there was an employee who filed a complaint with the EEOC in 2020, and their case was pending at the time that the administration changed, their case goes forward. The EEOC proceeds to go forward, and it gets handled regardless of the administration change. The same thing would happen at the Kansas human rights level. The charge would go forward, it would be investigated, there would be a finding, and the case would go forward. Regardless of changing of administrations, it would not get just dropped or lost just because there was a changing of the administration.
Walter and then Julie.
From an employer's perspective, what behavior does the NDO address that isn't already addressed by either the federal or the state law?
That is a very good question. Emily?
Okay, so you said on the employment side, what's new, what's newly covered. Again, like Teresa said, I mean, it's, you know, codifying gender identity and sexual orientation. It's going to be in the NDO, the language itself. Veteran status is going to be something that's new. It's already protected. Military status is protected by Kansas state law, but veteran status is not. Familial status is the other one that would be new.
So that's new in the NDA. And also the other language that's new and would be codified under sexual orientation and gender identity is that actual or perceived. That, you know, like I said, it's this sex stereotyping is a body of law, but it's not been phrased quite like that I've seen the actual and perceived. And then familial status being incorporated into the employment law is new. But again, the reality is, like, if I say I don't want to hire this woman because she has a bunch of small kids and she's going to always be gone, that's sex discrimination, even though it is also familial status discrimination. So there's overlap in the practical realities, even if the law doesn't explicitly call out some of these categories.
We'll go to Julie, and then Bev, I think you had a question. Okay.
Here we go. There we go. This may be a better question for tomorrow, but again, I'm a little unclear on the type of question that we ask.
And we're looking for questions for clarity now. Sure. Clarity about what's in the NDO.
Okay. So is there, or should there be, as it pertains to employment in the NDO, a provision for employees who have filed a complaint against their current or past employers? For example, if somebody's filed a harassment case against a former employer or against a current employer, is there any provision in there that prevents them from having anti-retaliatory acts performed against them? And as I'm aware, this only exists at the company policy level.
Definitely covered explicitly in federal and state law. Anti-retaliation provisions are explicit in federal and state law. And Emily, go to the NDO, because the NDO does have anti-retaliation language in it, but it doesn't, I think, show up in the provision that talks about prohibiting.
Section 2.06.040 about the purpose of the NDO and declaring civil rights. It's mentioned in the contracting provision relating to city contracts and anti-discrimination policies there. It's not mentioned as an unlawful discriminatory practice under section 2.06.050 though. So there might be.
As it's currently written, it is not written in that specific section, although it is mentioned in other sections. I can't tell you how the city would apply an anti-retaliation provision. That would be a question for someone other than me.
Bev, do you have a...
I'd like to know what recourse folks have if the NDO does not pass.
The recourse, so if you as an employee or as a person seeking housing or public accommodation feel that you have suffered discrimination, your recourse would be through the existing state or federal law. And so depending on if you're an employee, the number of employees within your employment, you could seek recourse either through the state law, if there were 4 or more, or through the federal law, if there were 15 or 20, depending on the law you were seeking recourse through. So existing state or federal law would be the recourse.
We
And it
have a
has.
question from Jeff.
Go ahead, Jeff.
So my understanding is that RFRA, and I know it's been talked about a little bit, is not a guaranteed outcome. It's basically a defense. So
reasonable factors other than age.
Okay, there you go. Yeah.
I was like RFRA.
Yeah, sorry.
Reasonable factors other than age.
Yeah. So then who ultimately will determine whether an application of the ordinance actually violates an individual's religious freedoms?
In the NDO, so the enforcement process is it goes through an investigation period, and then it goes to the law department to determine if there is probable cause, and then they do that burden determination. Would a penalty cause an undue burden? Is it furthering a compelling government interest in the least restrictive way? So the law department will make a probable cause or no probable cause determination, and then from there, it can end up going to an administrative hearing, and an administrative law judge would be appointed, and you'd have basically a trial, but not by a jury, by an administrative law judge would be the person who decided. And then from there, the administrative law judge will make a determination, and from there, either party could appeal to the district court under the existing Kansas Administrative Procedures Act.
So would there be, sorry, can I follow up? Would there be additional costs to the individual that is defending their religious freedoms through that process?
In this law, attorney's fees are covered by the parties. And so if either party hires an attorney, that party would be responsible for their own attorney's fees. There's no fee shifting provision in the NDO like there is in federal law, but not state law. So in federal law, there's a fee shifting provision where if the plaintiff prevails, they can get their attorney's fees paid by the defendant if they prevail, which is, years down the road. But here, each party has to bear their own attorney's fees. So to the extent you hire an attorney, you pay your own fees. And then at the administrative phase, we talked about this, Jackie and I talked about this. There is a provision where at the outset of a complaint, there's a mediation phase where you can try to mediate the dispute right at the front end. And there's a provision that says if you go to mediation and the mediator charges a fee, both parties split the fee. So that's another area where you can incur a cost, but neither party has to go to mediation. The way that the ordinance is written, either party could decline mediation. But beyond that, I didn't see a fee structure for the administrative phase. When you get into the court systems, there's usually a court filing fee. And then just your standard costs. right? Like costs for copying, costs for, if you take a deposition, that costs money, you know, anything that's associated with standard litigation.
Kendall, I know you have a question. I'd love to see who else has questions. Okay, so Kendall, then Gentry, then Bev. Who else wants to get in the next 15 minutes? Dion and Chuck. Thank you. Okay. And this doesn't mean we're done, but we're lining them up. Okay. Kendall.
My next question is about the time frame for relief being granted in these cases. So if the NDO was to pass, it would grant relief on a much sooner than the other courses would, correct? Than the state or federal level?
Yeah, it does set a schedule for when things occur that's like tighter than at the state or federal level. The statute of limitations is tighter at 60 days, and then I can't remember, Emily's probably got it in her handy dandy matrix. It's each step of the phase is a tighter time frame than you would find at the state or the federal level.
And so that statute of limitations, that would be a protection then for the respondent?
Correct.
Okay.
Correct. The respondent would, if you file your complaint on day 61 after the adverse action, the respondent would say, you didn't file timely, and that's one of my defenses. Yes, Gentry.
So in regards to housing, how is it legally, can you explain it to me, that the city can have a broader scope of protected categories than the state or the federal level?
Because they are their own elected body, and they can pass ordinances that cover kind of local, and it can't, you can't pass a law that is going to supersede the state law, but it can be more encompassing than state law. So you can't pass a Wichita ordinance that says, in Wichita, we are going to overrule the state law's prohibition on race discrimination. You can't do that, but you can be more expansive because they're their own kind of elected ordinance city.
I'd like to know if you can speak to the interpretation of, like, where equitable treatment intersects with religious discrimination.
I cannot, Bev.
Or what constitutes religious discrimination.
I think that the root of what you're asking is probably the heart of what you're trying to get to at these facilitated meetings. I can tell you what religious discrimination looks like in the employment context. You know, I asked for a religious accommodation so that I wouldn't have to work overtime on Saturday, and my employer said, oh, well, now you're fired. That would be an example of religious discrimination. Or I don't like people of X faith, so I'm not going to hire you because you're X faith. That would be a form of religious discrimination, but I don't think that's what you were asking me.
Let's go to Chuck.
This is, I hope, an easy one.
Ooh, me too.
What version of the ordinance are you working off of? Because there have been at least two, haven't there?
July 16th, 2021.
Thank you. So I do have a harder question than that. Who's going to be the investigator? The definition says that it's someone that the city manager appoints, but is that person going to be in-house? Are they from the outside? Does
I don't think
council
it's
have
necessarily in-house, and I don't know the answer. But the statute doesn't. I think it even contemplates.
I don't think it specifies. I just see the definition. Yeah, someone designated by the city manager. Let me see here real quick.
Yeah, so I don't know the answer to that question exactly, but I don't think that the statute specifically restricts it to being a city employee. Let me give you an example of how the state partners with other entities, and I don't know if the city would do that, but I'll just give you an example of the state. So the Kansas Human Rights Commission, they offer mediation services as well, but they use an outfit called Kansas or Midland Mediation. And so those are not, state employed by the agency. They're a separate entity, and they probably have a subcontract with the Kansas Human Rights Commission where some bit of the budget goes towards them to provide those mediation services. So I don't know if the city would do the same thing with regard to the investigative services.
Yeah, it doesn't say explicitly.
Sorry, go ahead, sorry. No. Oh, I wanted to go to Dion and then back to Nancy.
There was several comments made earlier, specifically the NDO is not intended to conflict with federal or state law. Tell me how that looks from someone who might be a plaintiff who files a complaint within the city. Is this like a doorway, a gateway for someone to then escalate their complaint? Like, is it an easy threshold for me to get a win at the city level, then take it to the state level, then take it to the federal level? Is that what we're seeing here?
I don't think I really have the answer to the question. I would say there's the EEOC and the KHRC, they have a sharing arrangement where if you file a charge at the KHRC and it's within the time frame, within the statute of limitations of the EEOC, it will be automatically dual filed with both agencies. And vice versa. If you file with the EEOC and it's within the statute of limitations for the state law, it is automatically dual filed with both agencies. But that is because there is a specific agreement between those agencies, and the EEOC has that arrangement with every state human rights commission across the country. That's not worked into this NDO, that there's some sort of automatic dual filing to escalate it to the state level. And practically, again, this is one of those, I don't know how it's going to shake out. Are you going to get a win in the shorter time frame at Wichita and then say, well, now I'm going to file with the state? There are some concepts in the law where you're supposed to kind of put it all out there at once. You know, you need to kind of bring all your claims forward at one time, but at the administrative agency level, it's not quite as clear. So I don't think I have a satisfactory answer for you on that.
Okay. I have another question, but I'll wait.
Okay, we'll go to Nancy and then Julie and maybe back to you then, Dion. And we're heading towards maybe 7:30 to wrap up questions. Nancy?
Thank you. I just had a question from one of the others. If I don't meet the 60-day requirement, then I can automatically go to the state, right?
Absolutely.
So
Yep.
60 days I can
just
do
the-
one way, but if it doesn't make it,
And if there's, you know, if the threshold in the employment context, if you have 15 employees, you can go to the EEOC. But that's where I think Dion was saying, like, once I go to the KHRC or the EEOC, I'm covered in both agencies by this automatic arrangement. And there's nothing that specifically in the NDO calls that out, that filing with the NDO automatically covers you under the state.
yeah,
Or the-
so something to consider there, yeah.
Okay, we were going to go to Julie, then Dion, and back to Robert. We're good with time. Okay, good. Thank you.
This question is in reference to the non-discrimination in contracting, specifically Section 3C. All city contracts shall include provisions prohibiting discrimination in employment for the performance of contracts on the basis of age, blah, 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 all of those things. So what it sounds like in this language, since it's prohibiting discrimination, it sounds like the language is written so that veterans' preference can no longer be considered. And that, in my viewpoint, is something that we don't want to discourage in the situations
Julie?
where that is relevant.
Excuse me, just try to keep it to the question. Okay. Yeah, thanks.
So would you interpret it that way?
No, I wouldn't, but I also haven't looked at it that closely. So I'm not sure. So you would again be required to apply or to comply with every law that applies to you. And so if you had a contract with the city and this language was incorporated into your subcontract. I'm not sure, I guess I don't really understand kind of how it would eliminate veteran preference requirements, but.
The city can't discriminate in any way against these things. And that would almost mean that, well, they can no longer discriminate
I see what you're saying.
as it comes to a veteran's preference.
Yeah. So I'd have to look into this more specifically. Honestly, Julie, I'd have to look into it more specifically. But for example, in the federal law and in the state law, there are, remember when we talked about those exceptions where you potentially could prefer one category over another? So in the context of affirmative action, so when you're a federal contractor, you might have an obligation to correct historical discrimination if, which might require that you make efforts, not necessarily fill a quota, but make efforts to recruit and expand your recruiting and hiring among protected categories that have historically not been represented in that workplace. Does that make sense? And so that's one of those.
That answers that at the federal level. And, you know, so as far as this NDO
As far as the NDO, I don't know.
So before we go to Dion and Robert, is there anybody who hasn't asked a question yet who has a question? Okay, so then Dion, Robert, Carrie, and Kendall. And we got to keep them tight. Did I miss anybody?
Well, this is specific questions about definitions. I see that we're talking about protected classes, and I don't see any information or comment on immutable characteristics of those protected classes versus the phraseology actual versus perceived. So when we're talking about immutable characteristics versus perception of gender fluidity, where does that leave the ordinance? Does that create holes in the ordinance for issues down the road that, as far as phraseology, that we don't actually give a definition in this ordinance that some people in the room might be concerned about?
So, again, I've just got so many unsatisfactory answers because a lot of these are me like looking into a crystal ball that I just don't have. I will tell you that none of the anti-discrimination laws at any level go into deep definitions of what it means, immutable characteristics of a race, or now sex. See, here's where sex was just sex. It was sex. What does the word sex mean? And it has been literally decades and decades of case law that has developed over decades to determine what sex means. And what constitutes sex discrimination has expanded and expanded over the decades to include a lot of things that in 1964, when the law was passed, it didn't necessarily cover or that wasn't contemplated. But none of the actual language of these laws goes into that level of detail that you're talking about. It's really been the court system that has kind of churned through these issues over time to interpret the law and decide what does this really mean. And the history of sex-based discrimination is just really, really interesting in terms of how it has been interpreted and expanded over time. And it's been the courts. It's been the courts.
So we won't be able to find a place that, as far as the crafters of this NDO, their intentions when they say or use the word protected class, there's might be multiple definitions of protected class or multiple definitions of immutable characteristics and or multiple definitions of perception as it relates to gender identity.
So I'm just thinking of the way that statutes are interpreted, and there's a lot of different, you have heard of strict constructionists, right? They just, what's the plain meaning of the word? I'm not gonna go any further than the plain meaning of the word. The statute says what it says, and I'm gonna use the plain meaning of the word. And then there are courts that look at legislative intent, and they dig into the body of materials behind the law, and they look at what was said during the debates about the law. And so some courts will look at legislative intent and try to use that. Other courts, they just look at precedent. They rely on persuasive precedent from their jurisdiction. So the Kansas courts very often rely on the federal law within the District of Kansas to interpret the Kansas law as a persuasive precedent. So there are a lot of ways that that laws get interpreted through the court system, and those are some examples. Emily, do you remember? You're much closer to law school than I was in constitutional law. Any others that I'm missing on sort of the ways laws get interpreted by the courts?
No, I mean, I think that's a pretty good covering.
And we're going to go to Robert, Carrie, and then Kendall. So let's keep these.
Robert, you have me shaken up here.
Really, let's keep these pithy. Oh, you do need a microphone. Yep.
Okay. You guys are very nice ladies and attorneys. God bless you. So, what prevents, with the way this is written, let's say there's an organization, and let's say there's a group of people that go, I want to cause a lot of trouble for this organization. Let's say they're a large employer. We're a small employer, but we have 15 jobs right now because of the bad market open for. What would prevent someone from saying, let's get a bunch of people to apply for these jobs? If they don't get hired, and all they have to do is say, we perceive we weren't hired because you don't like gay people or you don't like whatever. So someone like us could be in 3 lawsuits, 5 lawsuits, 7 lawsuits. The word perception scares the daylights out of me for everyone in the room, for all the businesses, because if someone wants to target that business, they don't like MyPillow. They don't like that company. So that's the question.
Yeah, good.
So if they don't like MyPillow or a local example of MyPillow or a liberal organization, and as a conservative that wants to throw a lot of lawsuits, what prevents there being many lawsuits against an organization with that word perceived, even if it's not true?
Let's
Yeah.
put the question there. I think we got it.
Yeah.
Okay. So, I work in the world of employment, and so there's the concept of at-will employment where you can be fired for any reason or no reason at all, with or without notice, except an illegal reason, right? And so I very frequently, my clients who are worried about legal action, you know, I always say you can be sued for any reason or no reason at all. There's nothing to stop people from taking legal action. There's a lot of things that stop them from winning. You have to have proof to win one of these cases. There are also tort laws, but they're really hard to prove. But there's tort laws that talk about abuse of process and malicious prosecution and things like that that do get applied when you have a litigant who's being frivolous. There's also rules within the profession of attorneys. There's a rule called Rule 11 where we are required to satisfy a minimum threshold of legitimacy before we take legal action. So there are some things in place to try to get control of a litigant who has gone out of control. Is there anything to stop them at the outset? Probably not.
No.
But there are things that you can try to work with on the back end to try to control it.
So we have 3 more minutes, and we're going to try to get 3 more questions in. Carrie, Kendall, and Shala has one, so you'll be our last question.
Okay, I'm going to go real quick. Is there language here that preserves a right to private action?
Yes, the Indio explicitly says that taking this course of action, filing a complaint with the City of Wichita, is not going to preclude you from enforcing your rights under any other state or federal law. So yes.
Oh man, you guys should get these over to Emily. Look, she's got the quick, easy answers.
Oh, I don't know. Hang on.
I'm just spinning up here.
Hey, my next question is regarding the difficulty level of filing at each level, filing a complaint. Would the local process be one that's perhaps less cumbersome and burdensome on somebody filing a complaint than going to the state or federal level?
I think they're all very simple and easy. The EEOC, I think, is really online at this point, and each of those agencies have people that, when I say help you file a complaint, I'm not saying they help you make your case. They just help you jump through the logistical hoops to get the complaint filed, like do this, then this, then this. I think it's fairly easy at every level.
Thank you. Shala?
My question is similar. Can you talk about the timeline with each filing agency, what that looks like, and if that could be shorter under the NDO?
It is shorter under the NDO. So you have to file under the NDO, you have to file a complaint with the city within 60 days of the adverse act, unless it's a continuing violation, which is something like ongoing harassment. And if it's ongoing harassment, it has to be within 60 days of the last act of harassment. At the state level, it's 6 months, and at the federal level, it's 300 days. So the NDO does have a much shorter timeline for filing.
I'm sorry, to further clarify, as far as the process for the, I guess, investigation.
Yeah, do you have that handy?
Yeah, I have a little bit here. I might need to scroll a little bit, but basically you file within 60 days. The other party has 30 days to file an answer, and then it'll go through an investigation process.
Or first they say you can mediate first if you want to mediate, but even that has to get done within a certain time period, like 30 or 60 days.
Within a certain time frame. And I'd have to go through for more specific details for you, but I can do that.
And that's with the NDO, so at the state and federal level, that's longer or different?
At the state level, I'm sure that there's language in all of these laws that say things like, you got to wrap it up by this time. The agencies do not usually wrap it up by the time, but the recourse is that the claimant who filed the complaint, they can go to the agency and they say, close it down, I'm just going to go file a lawsuit. I'm not going to wait for you anymore. So after a certain day, like at the EEOC, if your complaint's been sitting there for 180 days, you can go to the agency and say, shut it down, give me my right to sue, because you can't file a lawsuit unless you have that piece of paper under Title VII. And you can go to the agency and say, shut it down, it's been sitting here for too long, give me my paper, I'm going to go file a lawsuit.
And does that typically happen?
No.
Where it takes a long time at the federal level?
It takes a long time. It can be at the state and federal level, although they're getting faster and getting caught up, and it kind of depends. Like during COVID, it was this crazy shutdown. I would say without any intervention, a charge can be pending at the state or federal level from anywhere from 3 or 4 months to 8 or 9 months.
Mm-hmm. We're going to say thank you very much, and you'll be around, for the, and we are going to wrap up here at 8 o'clock. Teresa and Emily will stay around for a little bit, and we have one more activity. All right. Hey, everyone, just kind of want to take a collective moment to breathe and just acknowledge how tough it is to step into some of this stuff, and understanding the different spaces we represent when we come together collectively. But it's all in pursuit of making this community we are in better for those around us and those that come after us. So thank you. You're doing some really great work, but we want to get some live data into the room to come into tomorrow's piece, right? Like our 2.0 tomorrow. So well, we're going to get Julian transitioned. What we're going to do is you're going to need your cell phone device, all right? We're going to take a poll everywhere. Thumbs up if you're familiar with poll everywhere. Okay, some of us, great. It's real simple. There's this nice little cardstock 4x6 thing right here in front of you, okay? 2 ways we can access this, all right? You're gonna open up the camera and you're gonna QR code this. You hover that QR code, you're gonna see a link pop up at the bottom. That's gonna take you right to our poll. Hold on, we're gonna do it yet. We're just giving instructions. If you can't access it with your QR code, just open your browser and type that in right there. It's listed for you, pollev.com/KLC polls, okay? You're gonna be initiated 1 question at a time, okay? 1 question at a time. Before we get started, if you wanna peruse them, the first question we're gonna see, you're gonna have some responses to, is right up here. And if you've never been familiar with live data collection, as you give your indication to that question, we're gonna see it gathered, okay? Right here on the screen. We're not going to take time to do some sense making with it tonight. That's going into our part 2 tomorrow. Okay? So we're going to take this data tonight. Facilitators are going to come back, and we're going to have some consensus stuff that we're going to do with it tomorrow. Right? Okay. Thumbs up.
get that QR code. If you're not able to do it, give us a hand and we'll have some facilitators come over to help you. Okay? Right back here. Thank you, Jonathan. As you see, you're going to be prompted to do the first question.
We might have some reception problems.
Is it not?
I'm stuck. It's not me.
Can you put the Wi-Fi password?
Wi-Fi password, Julian. Up onto the Wi-Fi? Hey, thanks for bearing with us. Technology. Julian's going to get that. He's running.
We can use our hands.
We can use our hands.
To vote. Yes, no.
So, yeah, if the KLC guest Wi-Fi is the one that you want, KLC guest, not KHF, but KLC guest, here's the password. 316-712-4950.
Got it.
That's 316-712-4950.
I wish we had a post-it written it. Right there, Jim. Yeah.
You didn't get that, let me know, and I'll be happy to come back.
Say we're gonna audible. We're gonna get this post-it down here. Julia's gonna get it for us. You need that, Ju? Do you need the number? There will be. They're prompted one at a time, so we're gonna look at them together. Yep, we're gonna do them one at a time. Okay. KLC guest. Julia's got the password. If that's helping us. Great. Thank you. Okay. We're getting online engaged as well, so we're letting them get their answers in.
Again, everybody, the Wi-Fi is KLC guest, not KHF guest. KLC guest.
Right here, 316-712-4950. These results. You ready to go live? Okay. All right. Folks, name one aspect of the Non-Discrimination Ordinance you think people in this room will agree upon easily. A point of consensus. Again, we're going to have this all tomorrow. We're going to go through this, but we can just start seeing some of these ideas rolling in. One aspect that people in this room will agree upon easily, a point of consensus. From now till tomorrow when we meet again, we're going to have some think tank here among KLC to get this all downloaded in a manner that's presentable to you so that we can have some conversations, do some activities with it tomorrow in the hopes that we can look at language that's points of consensus and disconnect. we have all responses in? Okay, we're going to go on to the next question. We're going to close this poll. See there, have you been, do they need to re-log in, Julian, or are they prompted for the second one? Okay, responses for the second one. One aspect of the non-discrimination ordinance you think people in this room would not agree on easily. These are not points of consensus. This was our first one that rolled and said consider identity. That was our first one. Question. We're going to move on to the third question. Let's get some live data in the room. Did you? Did you not? We'll get it written down because we want it included in the activity. We didn't have one. Can we open it so we can submit? Yeah. He's open. Thanks for that, Robert. Because we want that collected, we can gather that. Okay. Question number 3. Question number 3. One aspect of the non-discrimination ordinance where people in this room may be able to agree to disagree. May. With that, we want to be real respectful of your time. We've got about 9 minutes left. I just want to give the most earnest, heartfelt thank you so much. I am not from the Wichita community. I am from Emporia, Kansas, live in the beautiful city of Cottonwood Falls, and I can feel the weight of making decisions and coming together to have conversations like this in this room. It's very palpable. So with that, thank you for this evening, and I invite you to come back tomorrow ready to dig deeper into these last 3 questions. We're going to have these responses collected. We're going to have them gathered for us to go into some conversations and engagement activities tomorrow. So with that, have a wonderful night. But before we leave, I want to give a very huge thank you to Ed O'Malley for hosting us at the Kansas Leadership Center and for allowing us to come together as a collective. And to our KLC team, thank you, Dennis, for hosting us and managing so many things between the city and the council and the board and our esteemed colleagues at KLC. With that, thank you. Thank you to those you work with. Have a wonderful evening. Come back tomorrow ready, recharged to continue the conversation. Thanks. Have a great night. Yep, leave them right there. Leave your Post-it notes, questions right on the table. Facilitators will be picking those up. Yep, leave. That'd be great.